for your testimony.
Thank you, Mr. Chairman.
Ms. Chaitman, you are recognized for 5 minutes.
Thank you. Thank you so much for giving me this opportunity.
And if you'll pull the microphone to your mouth, it's directional. Thank you.
Thank you so much for giving me this opportunity to speak to you. I speak on behalf of approximately 500 Madoff investors whom I represent, and I speak as well on behalf of every American who hopes to save enough money in his lifetime to retire on that money. I speak on behalf of every American who relies upon the brass plaque on his broker's desk, SIPC. We are told when we invest that every account is insured up to $500,000. And yet SIPC has taken the position in the Madoff case that the law doesn't apply to it. And if I had to grade the SEC's performance with respect to its essential function of protecting investors, with respect to the Madoff case, I would give the SEC an F. The SEC, instead of enforcing the law against SIPC, which it is charged by Congress with the obligation to do, instead of enforcing the law, we now know that in January 2009, the SEC agreed with SIPC that for the first time in its history, it would not pay SIPC insurance to each Madoff victim based upon the investor's last statement. SIPC is an insurance entity established by Congress which has the power to assess the Wall Street firms to raise the funds to protect investors. The statute doesn't give SIPC the right to define how it's going to allow a claim. The statute mandates that a claim is based upon the customer's last statement. And yet, the SEC joined in SIPC's violation of the statute. This is not just my opinion. This is the opinion of Chairman Garrett, who has proposed H.R. 757. And in proposing H.R. 757, which is simply a clarification of the law, one could view H.R. 757 as a statement to the SEC, you cannot avoid the law, and SIPC cannot avoid the law. Mr. Garrett made a statement when he had introduced this bill that SIPC has violated the law and the trustee in the Madoff case has violated the law. If you recall, in 1970, when SIPC was enacted, investors were encouraged to relinquish the protection of having certificated securities. That was something that Wall Street wanted. And in exchange for a relinquishment of that protection, investors were promised SIPC insurance. SIPC insurance was raised to $500,000 in 1978. It was never raised thereafter. But in the Madoff case, SIPC decided that was going to be too expensive for its Wall Street members, and so it was going to try to come up with an entirely new basis for insuring accounts. For the first time in SIPC's history, it decided it didn't insure the balance on the last statement. It only insured the net investment over the life of the account, which might have been 20 years, 30 years, 40 years. There is no evidence that any investor in today's stock market has of what he owns other than the statements he receives from his broker. We don't have the luxury of going back to certificated securities. The Internal Revenue Service relies upon those statements. Every investor relies upon those statements for planning their retirement, for planning their estate plans for their children. There is no basis in law for what the SEC did in this case. And this is not a question of insufficient funding for the SEC. This is a question of doing its mission, which is to protect the investor. Now, I'm not here to opine on whether or not Mr. Becker had a conflict of interest. I don't think there can be any doubt about it. But whether he advocated the constant dollar adjustment, which obviously reduced his own exposure, or whether he said to the SEC when he came on board in February 2009, you have made an illegal agreement with SIPC, which would have worked to his advantage, his judgment was clouded because everyone in the SEC forgot the law. There is one way to remedy this and to restore confidence in the capital markets for the average American, and that is to enact H.R. 757. Thank you.
Thank you for your testimony. I thank the panel for their testimony. And with that, we will begin questioning on our side by Dr. Gosar of Arizona. He's recognized for 5 minutes.
Chairman Shapiro, when David Becker, your brand new General Counsel, first came to you in February of 2009 and said, "My mother had an account with Bernie Madoff," why didn't you ask him any questions about it? Why didn't you even ask simple questions like, how much money?
Congressman, to the best of my recollection, and just so I can be clear, I haven't looked at any emails or whether there might be any contemporaneous notes or anything like that from this period of time. So I'm recalling back, because our Inspector General is looking at all this. So I'm recalling back 2 years ago. At the best of my recollection was that Mr. Becker told me that his mother, who had passed away years ago, had had an account at Madoff. I did not, because the account was closed years before, I did not think that the account of a long-deceased relative would raise an issue of a conflict of interest in Mr. Becker's work. I did expect that he would go to the Ethics Council. He's an experienced government official, government lawyer, served under 3 chairmen at the SEC, and we use our Ethics Council all the time for their advice. I expected him to run it by the Ethics Council and to follow their advice, and that's the way it went forward.
It seems that if the same situation existed in a publicly held or traded company that you were investigating, would you turn such a cavalier, have such a cavalier approach to that?
Well, it's hard for me to imagine this situation. I mean, these are the government ethics rules and the concern about
an ethics rule, nonetheless.
It's very hard to answer in the abstract. It would depend on the rule.
It just seems that there's a very different aspect that what's good in the private sector and publicly traded situations is not going well for the government. Let's go to my next question. Ms. Chaitman, do you believe that the account valuation method that David Becker recommended to the Commission as its attorney would have benefited his personal financial interest?
There is no question that the constant dollar approach, which apparently Mr. Becker invented, would benefit him personally and reduce his clawback exposure. But the more significant problem with the conflict of interest that Mr. Becker had is that it had clouded his judgment. The law is absolutely clear that every investor is entitled to SIPC insurance based on his last statement. And Mr. Becker had an obligation as the General Counsel of the SEC to make sure that the SEC complied with the law and enforced it against SIPC. And that's the great failure which has caused devastation to all of my clients.
Chairman Shapiro, your agency's Inspector General compiled a 457-page report about the SEC's failure to uncover Madoff's Ponzi scheme. That report devotes 2 sections out of 11 to describing in great detail every possible connection between SEC employees and Madoff. Do you think that your General Counsel's receiving funds from a Madoff account would have been appropriate material to the Inspector General or not?
That would be a much better question for the Inspector General. I have a pretty high level of confidence that he did quite a thorough report on the agency's failures with respect to Madoff.
The Inspector General's Madoff report mentions on page 382 that 2 family members of an employee in the Office of the Internet Enforcement invested $1.5 million and $500,000 respectively with Madoff. The Inspector General found it necessary to make sure that this employee had no involvement in any Madoff examination. Do you think that the Inspector General would have been interested in a similar situation involving your chief lawyer, a senior SEC official who served as General Counsel from 2000 to 2002 while the SEC was ignoring whistleblower complaints about Madoff?
I can't predict. I can imagine that he might have been, and of course he's looking at all of these issues now, and I expect that he'll thoroughly explore that.
Well, I understand that you inherited a horrific problem, but that it always starts with top-down. You know, private sector, businesses always look at accountability within the hierarchy. And it seems like we have a two-edged sword here. that we should have demanded a better accountability. Would you agree?
Congressman, I would agree that from where I sit now and understanding all the things that I understand now that I didn't understand in 2009, having arrived at the SEC and discovered that I had an agency in absolute ruin in some regards on my hands to manage, and not knowing, obviously, all the steps that would be taken by the trustee or the decisions the Commission would make down the road. But knowing those things now, I wish that we had I wish that Mr. Becker had recused himself, absolutely.
Gentleman's time has expired. The gentleman from Illinois, Mr. Quigley, is recognized for 5 minutes.
Thank you, Mr. Chairman. Madam Chairman, the New York Times reported on March 5th of this year that the SEC has declined to enforce the requirement from Dodd-Frank that would make rating agencies subject to expert liability under the securities law. This would make rating agencies liable for faulty ratings. Could you comment on the timeline for implementing this measure?
Yes, I'd be happy to. The way the rule works is that if a rating is included in a registration statement for securities, then the rating agency must consent to having liability, and that's the Dodd-Frank requirement. We had pre-existing SEC rules that required for asset-backed securities registration statements that if a rating was used to sell the securities, the rating needed to be included in the registration statement. Rating agencies have absolutely, unequivocally, at least the ones that are in existence now, refused to consent. So that made public offerings of asset-backed securities impossible, because they couldn't get the consent of the rating agencies to include the ratings, but they used the ratings to sell the securities. So we temporarily set aside our rule, our requirement that the asset-backed issuers disclose the ratings in their registration statements, because we didn't want to be holding up all public offerings of asset-backed securities and pushing them into the private markets, which we felt were not as good for investors. We are not, right now, our staff is working through a reconsideration of our disclosure requirements, and I believe that they will recommend that we eliminate our pre-existing requirement for including the ratings, and therefore the liability provisions can go forward. We're also hopeful that some of the newer rating agencies that have indicated an interest in becoming registered with us will actually be willing to consent, which is, I think, how Congress hoped the law would work.
Could you guess on the time frame for that?
I can't, but I'd be more than happy to. I would say over the next couple of months, but I'd be happy to get you a more definitive answer right away.
Thank you. And you talked about the agency that you inherited, and you talked about, to a certain extent, the reforms necessary, those you've implemented. But as to Mr. Katz's point, whether or not more assets, and I think